Lord Atkin very helpfully stated the ratio of Bell and Lever brothers in the form of a question, a test, if you will. Does the state of the new facts destroy the identity of the subject matter as it was in the original state of facts? And his answer, of course, was that it does not. What Bell and what Lever brothers had contracted for was the dissolution of Bell's employment contract. That is exactly what they got. The fact that Lever brothers could have had it for cheaper doesn't destroy the identity of the subject matter. And so the result was that Bell was entitled to his money, and common mistake as to identity or quality of the subject matter did not find application, or at least was not able in this instance to void the contract. There are a couple of things to note about Bell and Lever brothers. First, it was a House of Lords decision. This will become very important as we go through the list of cases. Second, it was a majority decision, so there were dissenting judgments. Third, and perhaps most importantly, the court in Bell had in fact considered questions of equity. Authorities from equity had been cited, and equity and procedure in general had been considered. Now this becomes very, very important when we move on to our next case, which is Soule and Butcher. Soule and Butcher followed 18 years after Bell and Lever brothers. In between these two cases, we had another case that we've already discussed, Leaf and International Galleries. And as you will recall, in Leaf, the court took a similarly restrictive view of when common mistake as to the quality of the subject matter could void a contract, because it didn't. Just like in Bell, it didn't find that the mistake that was present in those cases was of a nature that could void the contract. What is also important to note is that Bell and Lever brothers was a House of Lords decision. Leaf and International Galleries was a Court of Appeal decision, and Soule and Butcher was also a Court of Appeal decision. So technically, according to the rules of precedent, both Leaf and Soule should have followed Bell. They were bound by Bell. Facts of Soule and Butcher are fairly straightforward. This is a case about a landlord and a tenant. And the landlord and tenant had agreed on a tenancy at £250 per year. What neither the landlord nor the tenant knew at the time of their agreement was that the property at issue, the property that was being let out, was actually subject to something called the Rent Restrictions Act, which meant that the maximum rent chargeable for that property was not £250, but was in fact only £140. When the tenant found out about this, he sought to recover the difference of £110, this being the difference between £250 and £140. The court took a very interesting approach in this case. On the one hand, the court ostensibly followed the binding precedent in Bell and Lever brothers as confirmed in the subsequent case of Leaf and International Galleries, which was to say, or to ask in the first instance, has this mistake, that is the mistake as to whether or not the rent controls apply, has this mistake destroyed the identity of the subject matter of what was agreed between the two parties? And if we look at what happened in Bell, if we look at what happened in Leaf, we'd have to answer no. And this is what the court said as well. Because essentially, this was an agreement about letting out a flat. The tenant got their flat, the landlord got their money, the sum of money that was agreed. So in a sense, everything went ahead just as planned. This was a contract for renting of a flat, and that is exactly what happened. So just as in Bell, just as in Leaf, the amount paid is not something in those instances that destroyed the identity of the subject matter, and hence the contract was not held to be void in common law. Now that could have been the end of the story. However, the court, through Lord Denning, came up with a new doctrine altogether. So, while holding that the contract was valid at common law, the court also said that the tenant had an equitable right to void the tenancy. In other words, tenancy, while valid in common law, is voidable in equity. Now, this is very controversial because recall that Bell and Lever Brothers, House of Lords, had already laid down the law. And as Saul and Butcher was a decision of the Court of Appeal, they were bound by what the court had decided, the House of Lords had decided in Bell and Lever Brothers. Now, Denning, of course, argued that he had in fact followed binding precedent, namely by holding that the contract in Saul and Butcher was valid at common law. So, in other words, Denning was saying, well, this contract is not void at common law, but it is voidable in equity. In a sense, Denning created a new doctrine altogether, namely the doctrine of common mistake in equity, or perhaps more specifically, the doctrine of common mistake as to subject matter in equity. Now, before Saul, there was no such doctrine. There was only the doctrine of common mistake and the doctrine of common mistake as to subject matter. And it was assumed that these were doctrines of the common law, and that, of course, after the merger of equity and common law in the 19th century, that, in fact, equitable principles had been considered in coming up with that doctrine in the first place. And so, coming back to Bell, when we go and read the judgment in Bell, we will find that, in fact, the judges had considered equitable cases from the past. They had considered equity in general. They had considered equitable procedures as well. So it is wrong to say that somehow Bell only looked at the common law side and did not look at the equity side. But this, of course, then creates a much bigger problem, which is that it seems as if Saul did not follow binding precedent. And this, of course, is in breach of the rules laid down in Young and Bristol Aeroplane. Notwithstanding, a number of cases after Saul, in fact, followed Saul. One example is Grist and Bailey. Grist and Bailey is another case about buying and selling, renting land. Basically, in this case, there was someone who sold their property, and both the seller and the buyer believed that the property was sold with a tenant present at the time. So that would generally reduce the price of the property because whoever buys it cannot move in because there's still a tenant there. What was not known to the parties was that that tenant had in fact died, so what was being sold was really a vacant property. And once the seller found out about this, the seller decided not to go through with the transaction because the seller thought they could have gained a lot more money had they sold the property as a vacant property as opposed to one with a tenant. And the mistake is a common mistake. Both parties believed there was a tenant when there wasn't a tenant. The court decided that, again, following Saul and Butcher, that the contract stood as a matter of common law. But in equity, the court found that the contract was voidable. That means that the seller of the property was able to void the contract, not go through with the transaction. So the buyer, if they still wanted to buy the house, they would have had to have paid more because now both parties knew that there was no tenant involved. A similar case, although not involving real estate, is Mcgee and Peni insurance. What happened in Mcgee was that a father bought and insured a car for his son. The problem was that although the father wasn't driving the car because it was for the son, the father had no driver's license. Now the son got into an accident and as the insurance holder, the father then negotiated a settlement with the insurance, and the insurance settled the claim. The insurance later found out that the father did not have a driver's license. This meant that he had no valid insurance claim. But of course, the claim had already been processed, and the father and the insurance company had already agreed on settlement. So the question before the court was whether the agreement to settle the claim, was valid, or whether it was void. Once again, following Sol, following Grist, the court held that at common law, the contract was valid. However, in equity, the contract was voidable, and therefore, the insurance company was able to avoid having to pay for the claim. Of course, the trouble with all these cases is that they contradict binding precedent, namely the binding precedent in Bell and Lever Brothers. The issue was finally resolved in a very recent case, Great Peace Shipping and Zervillis Salvage. This is also a Court of Appeal decision. More on that later. What happened in Great Peace Shipping was that there was a ship in the Indian Ocean called the Cape Providence. And the Cape Providence was in some trouble and needed assistance from another ship. So the owners of the Cape Providence hired a company that deals with these matters called Zervillis Salvage. And in turn, Zervillis Salvage tried to find a ship in the area that could go and help. Zervillis Salvage found a ship called the Great Peace. Both parties, that means the salvage company as well as the owners of the Great Peace, both parties thought that the Great Peace was very close to the other ship, the ship in trouble, called the Cape Providence. They thought that the Great Peace was only 35 miles away and could go and help within a matter of hours. A few hours later, a few hours after the contract had been concluded between the salvage company and the Great Peace to go and assist the other ship, parties found out that in fact the Great Peace wasn't 35 miles away, it was more than 400 miles away, and it would have taken a lot longer to go and assist the stricken ship. At this point, the salvage company tried to look for another ship in the area which was closer in order for that ship to go and offer assistance. Zervillis also cancelled the contract with the Great Peace. Subsequently, the owners of the Great Peace sued. Zervillis argued that a common mistake had been made, namely a common mistake as to the location of the Great Peace, the ship that was going to help the stricken ship. The owners of the Great Peace argued that the common mistake was not so fundamental as to destroy the identity of the subject matter. In essence, if we apply the test, the Lord Atkin test out of Bell and Lever Brothers, and if we ask ourselves, do the new facts, namely that the ship was further away, do those new facts destroy the identity of the subject matter of the contract? The answer is no, because just like Bell and Lever Brothers was essentially about the dissolution of an employment contract, Great Peace Shipping and Zervillis, their contract was essentially about helping another ship that was stricken. Now, whether the ship, the Great Peace that was going to come and help, was 35 miles away or 410 miles away, meant a difference of whether it could come and help within a few hours or within around a day, around 22 hours. But even with this delay, the Great Peace could have still gone and done what the parties had contracted for, namely to aid the other ship. In other words, the fact that there was a delay did not render the performance essentially different from what the parties had envisaged. It simply delayed it. The difference to Sol, Grist, Mcgee, and so on was that in this case, the court held that that's the end of the story. In fact, the court held that there is no doctrine of common mistake in equity.